Let's now turn to Lesson 25, which looks at the third branch of the national government and asks the question, what is the role of the Supreme Court in the American constitutional system? I think you'll agree that just as in the case of the presidency, some question the extent of the powers that have been assumed by the Supreme Court. So let's ask, what are the constitutional powers of the Supreme Court? And in particular, can you address the meaning of original and appellate jurisdiction?
The creation of the Supreme Court inspired controversy almost from the day of its creation. And over the course of 200 years, Americans have expressed worries and concerns about the scope of power wielded by the federal judiciary, and in particular by the Supreme Court, bulked by concerns that the court had engaged in legislating rather than adjudicating, how the Constitution is interpreted and read, and principally whether or not judges ought to have the protection of lifetime terms as reflected in the guarantee of protection under Article 3 of the Constitution. When we talk about the court's power, we recognize that it has both original jurisdiction and appellate jurisdiction. The original jurisdiction is derived from Article 3, which provides that the judicial power of the United States shall be vested in one Supreme Court and other inferior courts created by Congress from time to time. The concept of original jurisdiction refers to the first court to hear a case, sometimes known as a court of first instance. And original jurisdiction then is constitutionally protected. Congress cannot add to it or subtract from it, as the Supreme Court said in the landmark case of Marbury versus Madison in 1803. The court's appellate jurisdiction then is conferred upon it by Congress, and it's left to Congress to decide, therefore, how much appellate jurisdiction to confer upon the court. The Supreme Court's appellate jurisdiction accounts for 95% of the cases that it hears in each term. Very few cases are heard on the basis of the court's original jurisdiction. Most of the cases come by way of appellate jurisdiction.
Which leads to the question of what is a writ of certiorari and under what conditions are they issued?
The court grants the writ of certiorari when, in fact, a disappointed litigant from an inferior court asks the court to hear the case. And writ of certiorari in its Latin form really means to issue a writ to be more certain of the lower court's disposition. And so the question arises, how does the court decide whether or not to grant the writ of certiorari? The court operates on the basis of the rule of four. Four justices out of the court have to agree to issue the writ of certiorari.
Is there any evidence at all that political considerations are taken into account when the court decides whether or not to issue a writ of certiorari?
There have been plenty of scholarly studies that have indicated that the court acts in a political way. Many articles, books have suggested that particular members of the Supreme Court are interested in shopping for cases in areas in which they're particularly interested, and it might be explosive or controversial areas. In abortion, for example, or busing in a day gone by have been two areas suggested by scholars as reflective of biases by the Supreme Court. But it's very difficult to know exactly why the Supreme Court decides to grant a writ of certiorari. It might be that it's disappointed with the earlier ruling by the appellate court. It might mean that that's an interest of the court's decision, and it might mean, for example, as it's typically explained, that the chief way in which the court will agree to hear a case is if the circuit courts are in conflict, because in those circumstances, the Supreme Court wants to draw order from the chaos that has engulfed an area of the law. And so the court wants to clear away or sweep away the differing interpretations on the assumption that because we are one nation under law, that it doesn't serve the interest of stability or predictability in American law if the law means one thing in one section of the country and another thing in another section of the country. Uniformity is a goal, as the Supreme Court said in some very important early 19th century cases.
Are you able to quantify what percentage of cases that the Supreme Court has heard deal with individual rights? And if you can you talk about some of the positive and negative consequences of the court's decisions in these cases?
Mm-hmm. I can't quantify the number or the percentage, but surely there have been some very important decisions rendered by the court in the spirit of promoting or safeguarding individual rights. We can go back to the early part of the 20th century to recognize some landmark cases in which the Supreme Court began, for example, to uphold rights of free speech that were very, very controversial, freedom of religion, and so forth. We can identify some particular cases where the court, moving forward, embraced its responsibility, as Chief Justice John Marshall said, to supervise the protection of the Constitution and particularly the Bill of Rights. If, for example, we looked at freedom of religion, we can identify arguments. We can look at Brown versus the Board of Education in 1954, where the court interpreted the 14th Amendment to prohibit racial segregation. We can look at the court's decision in 1965 in Griswold versus Connecticut, finding a constitutional right to privacy. Many of these decisions, of course, inspire controversy, often reflect the different views or opinions of Americans across the country, but certainly for every decision we can cite by the Supreme Court to advance or to protect civil rights and civil liberties, we can probably identify some cases that have restrained or undercut civil rights and civil liberties of the American people. For example, the Japanese internment cases recognize a very, very dark point in American history. Long before the Supreme Court would recognize rights of women under the 14th Amendment to equal protection and due process, in cases in which the court would knock down barriers to gender equality. There was a time in which the Supreme Court held that women, for example, had found no protection under American law during the period in which the doctrine of coverture ruled, and women were relegated to a second-class citizenship. So the record remains checkered, and in order to better appraise the record of the Supreme Court, we would need to look at specific areas to see whether or not the court truly advanced particular freedoms protected under the Bill of Rights. I would say, just to take one area, that the court has been pretty judicious, very good in protecting freedom of the press, that over the course of our history, the court's decisions in the area of free speech have gone from a miserly view of protecting speech to a much more expansive view. And if we looked at the area of women's rights, we would certainly say the same of that area, as well as civil rights for African Americans and other minorities.